The BART Office of the Inspector General proudly presents its report, District Followed Procedure and the Law in Imposing Discipline. Here's Ed to tell us about the investigation.
Thanks, Heidi. The OIG received an allegation that BART was inconsistent in administering employee discipline. Because our legislative mandate requires that we review and recommend best practices that BART should follow to maintain positive and productive relations with its employees and collective bargaining units representing those employees, we decided to launch an investigation. Although we are mandated to improve union and district relations, we do not have authority over disciplinary actions. Therefore, we focused our investigation entirely on whether the district followed proper procedure in determining discipline for an employee named in the allegation and facing termination. As such, we did not examine a statistical sample of similar employee disciplines, and we have no conclusions regarding the district's consistency in imposing employee discipline. For the discipline called into question, we determined that the employee had received a pre-discipline notice for a failure to follow safety procedures. This notice was provided to the employees' union as required under the applicable collective bargaining agreement, and was a factor in the district's decision to terminate employment. It is permissible for the district to rely on pre-discipline notices when imposing discipline. Disciplinary decisions may be made on a case-by-case basis, and employers may apply factors such as the employee's personnel history, mitigating factors like unclear or unreasonable rules, and aggravating factors such as prior notices or adverse actions in their disciplinary decisions. The district provided to the employee and their union all evidence used to support the district's disciplinary decision as required by law and in compliance with the relevant collective bargaining agreement. Not all documentation collected by the district during its investigation of employee misconduct must be presented to the employee or their union. Only that which the district relies on to support the disciplinary decision. The district held a Skelly hearing giving the employee the opportunity to challenge the discipline and refute the allegations by presenting exculpatory evidence or witnesses. The employee was removed from duty but kept on paid status following the incident leading to the discipline and was required to retrain on their job duties. This is standard after a safety incident and is not considered formal discipline, therefore, the employee was not disciplined twice for the incident. BART operations rules and procedures state, in case of doubt in any situation, the safest course of action must be taken. This allows and requires an employee to not follow their manager's directives if those directives pose a safety hazard. Employers may consider contrition in the disciplinary decisions. Contrition allows an employer to make a determination as to whether the imposed discipline will lead to corrective action by the employee. Based on these factors, we determined the district followed procedures and the law in making their disciplinary decision. In summary, differing mitigating or aggravating factors can lead to employees receiving different forms of discipline even when facts and circumstances leading to discipline are similar, including among employees involved in the same incident. In regards to the discipline in question, those factors played a role in the district's decision. Well, thanks for listening in. We've had a long day at the office and are heading home, using BART, of course. Take care.